by Ikechukwu Nnochiri The Nigerian judiciary is indeed passing through a trying time. Never in the annals of the country was this arm of the government enmeshed in a corruption scandal of the magnitude that is currently threatening to erode its integrity. Suspended Chief Justice of Nigeria, CJN, Justice Walter Samuel Nakanu Onnoghen. The federal government had, in an unprecedented move on January 11, dragged the Chief Justice of Nigeria, CJN, Justice Walter Onnoghen, before the Code of Conduct Tribunal, CCT, for trial, accusing him failing to declare his assets as prescribed by the law. In the six-count charge marked CCT, ABJ 01-19, FG, equally accused Onnoghen of maintaining 5 separate foreign bank accounts, in breach of the Code of Conduct for public office holders. The charge followed a petition dated January 7, which was lodged against the embattled CJN by a group under the aegis of Anti-Corruption and Research-Based Data Initiative. The Code of Conduct Bureau, CCB, which received the petition on January 9, at the end of its investigation that lasted 48 hours, recommended Justice Onnoghen for prosecution at the CCT. Onnoghen, lawyers ask NBA to derobe Malami, Danladi Umar, others. Consequently, the CCT summoned the defendant to appear before it on January 14 to enter his plea to the charge. Specifically, some of the allegations against Onnoghen read, that you, Justice Walter Nakanu Onnoghen, CJN, GCON, between the 8th of June 2005 to the 14th of December 2016, being a public officer serving as a judicial officer in the Federal Republic of Nigeria as a Justice of the Supreme Court, failed to declare and submit a written declaration of all your assets and liabilities within the prescribed period of 3 months after being sworn in as the Justice of the Supreme Court of Nigeria on the 8th day of June 2005, and you thereby contravened the provisions of Section 15(1) of the Code of Conduct Bureau and Tribunal Act Cap C 15 LFN 2004 and punishable under Section 23(2) A, B, and C of the same Act. That you, Justice Walter Nkanuonnoghen, CJN, GCON, being a public officer as Justice of the Supreme Court of Nigeria who is under a duty to declare his assets to the Code of Conduct Bureau Chief on or about the 14th of December 2016, falsely declared your assets in your Declaration of Assets Form CCB1, after you were sworn in as Justice of the Supreme Court of Nigeria, by omitting to declare a domiciliary US dollars account No. 870,001,062,650 maintained with Standard Chartered Bank of Nig Limited, WUS2, Abuja, which is being operated since 2011, and you're thereby contravened the provisions of Section 15(2), read along with Section 151 of the Code of Conduct Bureau and Tribunal Act Cap C 15 LFN 2004 and punishable under Section 23(2) A, B, and C of the same Act. That you, Justice Walter Nkanuonnoghen, CJN, GCON, being a public officer as Justice of the Supreme Court of Nigeria who is under a duty to declare his assets to the Code of Conduct Bureau Chief on or about the 14th of December 2016, falsely declared your assets in your Declaration of Assets Form CCB1, after you were sworn in as Justice of the Supreme Court of Nigeria, by omitting to declare a domiciliary Euro account No. 93,001,062,686 maintained with Standard Chartered Bank of Nig Limited, WUS2, Abuja, which is being operated since 2011, and you're thereby contravened the provisions of Section 15(2), read along with Section 151 of the Code of Conduct Bureau and Tribunal Act Cap C 15 LFN 2004 and punishable under Section 23(2) A, B, and C of the same Act. Group tackles party chairman who called for Buhari's impeachment. Meanwhile, Justice Onnoghen, on January 14, declined to appear before the Mr. Danladi Umar-led 3-member CCT panel to be arraigned by FG. Instead, the CJN, through a consortium of lawyers led by a former president of the Nigerian Bar Association, Chief Wole Olanipekan, SAN, and a former Attorney General of the Federation, Chief Kanu Igabi, SAN, challenged the jurisdiction of the CCT to handle the case against him. He contended that FG's failure to channel the petition against him, as well as the outcome of the investigation that was purportedly conducted on his assets declaration forms by the CCB, to the National Judicial Council, NJC, before it rushed the case to the CCT. The CJN further argued that FG failed to abide by existing judicial precedent as encapsulated in a recent appeal court decision in Onnoghen v. Federal Republic of Nigeria, 2017, LPELR 43391, CA, to the effect that any misconduct attached to the office and functions of a judicial officer must first be reported to and handled by the NJC, pursuant to the provisions of the laws. He maintained that only after the NJC has pronounced against such judicial officer could prosecuting agencies of the federal government proceed to initiate a criminal proceeding. Placing reliance on a recent decision of the CCT on a similar charge FG lodged against another justice of the Supreme Court, Sylvester Ngwuta, the CJN's legal team insisted that FG's decision to sideline the NJC stripped the tribunal off its jurisdiction to entertain the instant case. The same day, FG filed a motion for the tribunal to compel Justice Onnoghen to step aside as the CJN and chairman of the NJC, and for him to hand over to his next-in-command, Justice Tanko Muhammad. While the CJN was contending with the CCT, 3 separate high courts, as well as the National Industrial Court, issued interim injunctions stopping the tribunal from taking further steps in the matter. On January 21, in a 2-to-1 split decision, the CCT panel said it would proceed with the trial, despite the court orders. Dissatisfied with the decision, Onnoghen proceeded to the Abuja division of the Court of Appeal where he secured an order that suspended further proceedings at the CCT, pending the determination of an appeal he lodged against his trial. Anti-Onnoghen's protests rock Abuja. In the appeal he lodged on January 15, Onnoghen argued that the Mr. Danladi Umar-led tribunal erred in law when it held that the preliminary objection he filed to challenge the competence of the charge would be heard alongside the motion FG filed for him to step aside. Onnoghen insisted that it was wrong for the tribunal to hear and determine FG's motion when its jurisdiction to entertain the substantive charge was being challenged. He therefore prayed the appellate court to set aside the decision of the CCT as contained in a ruling its chairman delivered on January 14. Meantime, before the appeal could be heard, Justice Onnoghen, on January 18, filed the motion. The appellate court, on January 24, relied upon to temporarily suspend further proceedings in the case. Unknown to both the appellant and the court, FG had the previous day, January 23, persuaded the CCT to issue an ex parte order for the defendant to be suspended from office, pending the conclusion of his trial. Thus, in a move that took Nigerians by storm, President Muhammadu Buhari, on January 25, suspended Justice Onnoghen and swore in the next most senior jurist of the Supreme Court, Justice Muhammad, to take over the leadership of the judiciary as the acting CJN. The action of the president elicited varied reactions from both within and outside the judicial circles, with the NBA describing it as a coup against the judiciary. The Nigerian Bar Association unequivocally rejects and condemns this attempted coup against the Nigerian judiciary and evident suspension of the Nigerian constitution by the executive arm of the federal government. Presidential poll, court fixes January 31 to hear suit seeking to disqualify Buhari. The action of the executive portends a slide into anarchy and complete deconstruction of the rule of law and due process. It amounts to an absolute breach of the Constitution and the usurpation of the powers of the Senate and the Nigerian Judicial Council, NBA, which is the umbrella body of lawyers in the country, stated. Onnoghen was suspended barely 8 hours after he announced his decision to inaugurate judges that will take charge of the 2019 election petition tribunals. He had in a statement that was signed by his senior special assistant on media, Mr. Awasam Bassi, said he would, as part of his duties, swear in members of the 2019 National Assembly governorship. To further register its displeasure over the action FG took against Onnoghen, the NBA ordered a 2-day boycott of court activities in the country by lawyers. The legal body further constituted a 3-member committee to liaise with the government with a view to finding an amicable resolution of the crisis bedeviling the suspended CJN. Likewise, 25 constitutional lawyers dragged President Buhari before the Federal High Court in Abuja to challenge what they termed as illegal suspension of the CJN, Onnoghen. The suit was filed on January 28, which was a day the CCT okayed indefinite adjournment of proceedings before it to await the outcome of Onnoghen's appeal. The plaintiffs, led by human rights activist, Mr. John Mary Jidiobi, posed 2 legal issues for the determination of the court. Prosecution of CJN Onnoghen at this time raises red flags. They prayed the High Court to determine whether by the combined interpretation of Section 153(1)(I), paragraph 21 of the Third Schedule and Sections 271, 291, 292 and 231 of the amended 1999 Constitution of the Federal Republic of Nigeria, and especially in view of the Supreme Court decision in El Habib v. AGF 201213 NWLR PT 1318, there exists any authority in the first defendant Buhari to suspend the fourth defendant Onnoghen as the Chief Justice of Nigeria, as well as whether by the combined interpretation of Section 153(1)(I), paragraph 21 of the Third Schedule and Sections 271, 291, 292 and 231 of the amended 1999 Constitution of the Federal Republic of Nigeria, and especially in view of the Supreme Court decision in El Habib v. AGF 201213 NWLR PT 1318, the purported suspension of the fourth defendant as the Chief Justice of Nigeria by the first defendant on the 25th of January 2019 is not unconstitutional. Upon determination of the questions, the plaintiffs asked the court to hold that President Buhari lacked the constitutional power to suspend Onnoghen as the CJN. A declaration of this honorable court that by the combined interpretation of Section 153(1)(I), paragraph 21 of the Third Schedule and Sections 271, 291, 292 and 231 of the amended 1999 Constitution of the Federal Republic of Nigeria, and especially in view of the Supreme Court decision in El Habib v. AGF 201213 NWLR PT 1318, the purported suspension of the fourth defendant as the Chief Justice of Nigeria by the first defendant on the 25th of January 2019 is of no legal force, unconstitutional and a nullity. An order of this honorable court restoring the fourth defendant forthwith to his office as the Chief Justice of Nigeria. Likewise, an order of perpetual injunction of this honorable court restraining the first defendant or any other person acting on his behalf or at his direction from further suspending the fourth defendant from his office as the Chief Justice of Nigeria. Aside President Buhari, other defendants in the suit marked FHC, ABJ, CS, 113-2019, were the NJC, the acting CJN, Justice Muhammad, and the suspended CJN, Justice Onnoghen. Meantime, on January 30, the appellate court cleared the coast for FG to open its case against the suspended CJN. The appellate court, in a unanimous ruling by a 3-man panel of justices, vacated its initial order that stopped the CCT from taking further steps in Onnoghen's trial. In the lead ruling that was delivered by Justice Abdul Aboki, the appellate court held that granting the suspended CJN's motion to stop his trial would amount to a fundamental interruption of a criminal proceeding before the CCT. Onnoghen, lawyers boycott courts in Bayelsa, Delta, Ibom, Rivers. It noted that Onnoghen himself had in a judgment he delivered in a case involving a firm owned by former National Publicity Secretary of the People's Democratic PDP, Chief Olisa Mehta, Destra Investment Limited, banned the grant of stay of proceeding in criminal matters. Justice Aboki further recalled that the suspended CJN had in another case that involved the Senate President, Dr. Bukola Saraki, identified the CCT as a special court with quasi-criminal jurisdiction. He maintained that Section 306 of the Administration of Criminal Justice Act, 2015, expressly forbade courts from granting orders to stay proceedings in criminal cases. We cannot run away from the fact that the CCT, which has quasi-criminal jurisdiction, does not have an option than to abide in apolitical the criminal laws in all proceedings before it, Justice Aboki added. Consequently, the appellate court dismissed Onnoghen's appeal, stressing that the order for stay of proceedings he requested for could not be granted as a matter of cause. An applicant must convince the court that grant of such order will be in the interest of justice, the court held, saying there was no special or exceptional circumstance to warrant the suspension of the case pending against Onnoghen before the CCT. The applicant's motion for an order for stay of proceeding is hereby refused, Justice Aboki ruled. Nevertheless, the appellate court fixed next Monday to hear the substantive appeal the suspended CJN filed to challenge decision of the CCT to hear his preliminary objection alongside FG's motion to remove him from office. Onnoghen, lawyers boycott courts in Bayelsa, Delta, Ibom, Rivers. Besides, Justice Onnoghen also lodged another appeal to challenge the ex parte order the CCT issued for his suspension. In his 4 grounds of appeal, Justice Onnoghen argued that the Mr. Umar-led CCT erred in law by granting an ex parte order for his removal, even when its jurisdiction to entertain the 6-count charge the federal government leveled against him was being challenged. He therefore applied for an order setting aside the order of the tribunal made on the 23rd of January, directing the appellant to step aside as the Chief Justice of Nigeria and a further order that the President of the Federal Republic of Nigeria takes all necessary measures to swear in the most senior justice of the Supreme Court of Nigeria as acting Chief Justice of Nigeria and Chairman of the National Judicial Council. The suspended CJN contended that the exercise of powers over the motion ex parte without first determining the jurisdiction of the tribunal amounted to unlawful exercise of jurisdiction and therefore void. Aside the legal angles, the NJC also waded into the crisis by directing the suspended CJN to within 7 working days respond to allegations against him. NJC, which is the organ of the judiciary responsible for the appointment, promotion and discipline of judicial officers, at the end of an emergency meeting it held last Tuesday, also gave the acting CJN, Justice Muhammad, the same number of days to explain why disciplinary action should not be taken against him for submitting himself to be sworn in by President Buhari as Onnoghen's replacement. Basically, the NJC directed the suspended CJN to respond to a petition that was lodged against him by one Zikrulahi Ibrahim of Resource Center for Human Rights. It was learned that the petitioner is accusing Onnoghen of being in possession of funds and properties that are way beyond his legitimate earnings. On the other hand, the council asked the acting CJN, Justice Muhammad, to respond to 2 separate petitions that were entered against him by a group under the aegis of Center for Justice and Peace Initiative, as well as by a former president of the Nigerian Bar Association, NBA, Chief Olisa Agbokoba, San. Agbokoba had in his petition urged the NJC to determine the propriety of Justice Muhammad accepting to be sworn in by the president in place of the suspended CJN, despite being aware of the implication of his conduct. Removal of Onnoghen as CJN is proper, timely, forum of presidential candidates according to Agbokoba, by submitting himself to the president to be sworn in as acting CJN. Justice Muhammad lent himself to constitutional infraction by the executive arm of government. He recalled that Justice Muhammad was a member of the panel that sanctioned Justice Obisai Korji of Abia State for allowing himself to be sworn in as Abia State Chief Judge by the state's governor, without recourse to the NJC. Agbokoba accused the acting CJN of engaging in an act of judicial misconduct. Similarly, the NJC, in a statement that was signed by its Director of Information, Mr. Soji Oyo, did forwarded another petition that was filed against the CCT chairman, Mr. Umar, to the Federal Judicial Service Commission, FJSC. A group under the platform of Center for Justice and Peace Initiative had urged the NJC to sanction the CCT boss for engaging in reckless abuse of his judicial powers. However, the council said the FJSC was the appropriate constitutional body empowered to deal with issues the petitioner raised against the CCT chairman. Already, the NJC said it has furnished both Onnoghen and Mohammed with copies of the petitions against them, adding that it abridged their response time to 7 days, owing to the gravity of the matters involved. The council said it would reconvene on February 11 to consider responses of the affected parties. This is even as the CCT has declared its resolve to resume proceedings on the charge against Onnoghen on Monday. Meanwhile, ahead of the scheduled resumption of the trial, embattled CJN opened up on some of the allegations against him, especially as it relates to foreign currencies traced to his bank accounts. In a cautionary statement form, he filed at the Department of Intelligence Investigation and Monitoring, CCB, in Abuja. Onnoghen said the deposits were from trading in foreign exchange, forex, erode, as well as proceeds of his investments. In the statement, Onnoghen averred that the deposits made in my US dollar account number 87,106,250 with STD. Chartered Bank of $10,000 at different intervals of June 28, 2011 were sourced partly from my reserve and saving from my ESTA codes, including medical expenses. The same applies to my deposit of July 28, 2011, of $10,000 twice. It is important to state that prior to my opening the US dollar account, I had foreign currency, which I kept at home, due to the fact that there existed a government that proscribed the operation of foreign currency account by public officers including judicial officers. It was when I got to know that the policy had changed that I had to open the said account. Upon opening the account, I was made to understand that I cannot pay in more than $10,000 at a time, and per payment slip, I cannot remember the total amount I had on reserve at the time, but it spread from my practice days as a private legal practitioner from 1979 to 1989. Onnoghen Gate, over 300 lawyers defy rain, block governor's office in Calabar. Some of the deposits are a result of forex trading, AGRICOD, and other investment returns were from proceeds of my investments into them. The withdrawals in the account are partly to pay children's fees, upkeep abroad and further investments. My British pound and euro accounts with Chartered Standard Bank are savings accounts. In the January 1, 2019 document, the suspended jurist, who wrote his statement on January 11, 2019, between 12:30 p.m. to 1:45 p.m. added, I, Walter S. N. Onnoghen, for the Supreme Court of Nigeria, hereby, voluntarily deposed to the statement averred herein, knowing that whatever I write or state may be tendered against me as evidence in court. I also volunteer to state that the statement was not taken in evidence from me under duress but after the administering officer had explained and made known the details of the allegations against me. In response to allegations of non-declaration of his assets, Justice Onnoghen said, my asset declaration for numbers SCN 00014 and SCN.00005 were declared on the same day, December 14, 2016, because I forgot to make a declaration of May 2005 of my assets after the expiration of my 2005 declaration in 2009. Following my appointment as Acting Chief Justice of Nigeria in November 2016, the need to declare my asset anew made me to realize the mistake and then did the declarations to cover the period in default. I did not include my Standard Chartered Bank account in SCN 00014 because I believed they were not opened during the period covered by the declaration. I did not make a fresh declaration of asset after my substantive appointment to CJN because I was under the impression that my SCN 00015 was to cover the period of 4 years, which includes my leave as CJN. The petitioner had asked FG to investigate the origin of huge foreign currencies they said were found in Onnoghen's accounts. The petition read, we write to bring to your attention serious concerns bordering on flagrant violations of the law and the Constitution of Nigeria by the Honorable Mr. Justice Walter Samuel Nakanu Onnoghen, the Chief Justice of Nigeria. Specifically, we are distressed that facts on the ground indicate the leader of our country's judicial branch is embroiled in suspected financial crimes and breaches of the Code of Conduct Bureau and Tribunal Act. The particulars of our findings indicate that His Lordship Justice Walter Onnoghen is the owner of sundry accounts primarily funded through cash deposits made by himself, up to as recently as the 10th of August 2016, which appear to have been run in a manner inconsistent with financial transparency and the Code of Conduct for Public Officials. To give specific examples, here are some instances of cash deposits by Justice Onnoghen. Justice Onnoghen made 5 different cash deposits of $10,000 each on the 8th of March 2011 into Standard Chartered Bank account $1,062,650. On the 7th of June 2011, 2 separate cash deposits of $5,000 each were made by Justice Walter Onnoghen, followed by 4 cash deposits of $10,000 each. On the 27th of June 2011, Justice Onnoghen made another set of 5 separate cash deposits of $10,000 each and made 4 more cash deposits of $10,000 each on the following day, the 28th of June 2011, FGN v. CJN, Appeal Court Judgment on Justice Nanjiwa, Hun. Justice Walter Onnoghen did not declare his assets immediately after taking office, contrary to Section 15(1) of Code of Conduct Bureau and Tribunal Act, Hun. Justice Walter Onnoghen did not comply with the constitutional requirement for public servants to declare their assets every 4 years during their career. The Code of Conduct Bureau forms, Form CCB1, of Hun. Justice Walter Onnoghen for 2014 and 2016 were dated and filed on the same day. The acknowledgement slip for declarant SCN 000014 was issued on the 14th of December 2016. The acknowledgement slip for declarant SCN 000015 was also issued on the 14th of December 2016, at which point Justice Onnoghen had become the Chief Justice of Nigeria. The affidavit for SCN 000014 was sworn to on the 14th of December 2016. The affidavit for SCN 000015 was sworn to on the 14th of December 2016. Both forms were received on the 14th of December 2016 by one Awal Usman Yakasai. The discrepancy between Justice Walter Onnoghen's 2 CCB forms that were filed on the same day is significant. In filling the section on details of assets, particularly cash, in Nigerian banks, His Lordship as declarant SCN 000014 mentioned only 2 bank accounts, Union Bank account number 0021464934 in Abuja, with balance of N9,536,407, as at the 14th of November 2014. Union Bank account number 0012783291 in Calabar, with balance of N11,456,311 as at the 14th of November 2014. The sources of the funds in these accounts are stated as salaries, estacodes and allowances. As declarant SCN 000015, His Lordship however lists 7 bank accounts, Standard Chartered account 0001062667, with balance of N3,221,807.05 as at the 14th of November 2016. Standard Chartered account 0001062650, with balance of $164,804.82, as at the 14th of November 2016. Standard Chartered account 5,001,062,686, with balance of euros 55,154.56, as at the 14th of November 2016. Standard Chartered Bank account 5,001,062,679, with balance of £108,352 and 20 pence, as at the 14th of November 2016. Standard Chartered Bank account 5,001,062,693, with balance of N8,131,195.27, as at the 14th of November 2016. Union Bank account 0021464934, with balance of N23,261,568.89, as at the 14th of November 2016. Union Bank account 0012783291 with balance of N14,695,029.12 as at the 14th of November 2016. The foreign currency Standard Chartered Bank accounts that were declared by declarant SCN 000015 have been in existence since at least 2011. Alleged N450 fraud. Court dismisses charge against Taraba APC Gov candidate. Two others. Prior to 2016, His Lordship appears to have suppressed or otherwise concealed the existence of these multiple domiciliary accounts owned by him, as well as the substantial cash balances in them. The Standard Chartered Bank dollar account $1,062,650 had a balance of $391,401.28 on the 31st of January 2011. The Standard Chartered Bank euro account $5,001,062,686 had a balance of euro 49,971.71 on the 31st of January 2011. The Standard Chartered Bank pound sterling account $5,001,062,679 had a balance of 23,409 British pounds and 66 pence on the 28th of February 2011. It is curious that these domiciliary accounts were not declared in one of the two CCB forms filed by Justice Onnoghen on the same day, the 14th of December 2016. The Naira Bank accounts in BI and BV above are also omitted in the CCB form of declarant SCN 000014. It is our humble view that, with the foregoing, we have laid before you facts which support the assertion that Justice Walter Onnoghen may have committed a breach of the provisions of the Code of Conduct Bureau Act as follows: non-declaration of assets immediately after taking office. In several capacities prior to becoming the Chief Justice of Nigeria contrary to Section 15 of the Code of Conduct Bureau Act, non-declaration of assets immediately after taking office as the Chief Justice of Nigeria contrary to Section 15 of the Code of Conduct Bureau Act. Non-declaration of assets at the statutory intervals after taking office throughout his career as a federal judicial officer contrary to Section 15 of the Code of Conduct Bureau Act. False declaration of asset, and in particular, concealment of significant and declarable assets in the form of sundry bank accounts and the balances therein, contrary to Section 15 of the Code of Conduct Bureau Act. Onnoghen takes FG to court over suspension. Consequent to this information, it is our expectation and request that you will discharge the constitutional duty of your office and take the necessary lawful actions to uphold and enforce the law in this matter by involving sister agencies such as the Nigerian Financial Intelligence Unit (NFIU) to conduct comprehensive statistical analysis of cash transactions on all the accounts for cases of suspicious transactions. The Nigerian Financial Intelligence Unit (NFIU) to determine whether Standard Chartered Bank has not breached statutory duties to the Nigerian state in favor of or in connivance with His Lordship on suspicious transactions reporting (STR). The Revenue Mobilization Allocation and Fiscal Commission (RMAFC), the Supreme Court of Nigeria and the National Judicial Council (NJC) to determine whether the disclosed financial transactions are justified by His Lordship's lawful remuneration. As ordinary citizens, motivated by a clear belief that there must be high standards in public life, we have acted to expose